Welcome once again to Lehto's Law. Here's Steve Lehto.
Another update on that wacky lug nut story out of Michigan. I've done this story about how the Michigan Court of Appeals ruled that a mechanic can start a job but not finish it, and that will mean that he's performed the job. And so if the half-finished job hurts somebody, you can't sue him under the Motor Vehicle Service and Repair Act because the guy did his job. He performed it. And I did 2 videos about this. The story's been picked up all over the place. Jalopnik did a great article on it. And just this morning, I woke up and I read the Detroit News, as I do every morning. And Neil Rubin of the Detroit News is a columnist who I'll tell you I've spoken to before several times. And he's written some really, really cool articles about turbine cars and guys who write books about turbine cars, things of that nature. And the headline, and this is a Sunday morning article, but it's actually going to appear in the Monday print editions of the Detroit News. And I'll put a link to the article in the description below. Court, tightened lug nuts, not guaranteed entire rotation. Neil Rubin. And here, I'm just going to read you the article. As an attorney, Steve Lehto is not supposed to disparage the courts. But after an appeals panel's decision last month involving lug nuts, legal fees, and the definition of the word perform, he said he's off the hook because, quote, they ruled in such an idiotic fashion that they are disparaging themselves, unquote. Specifically, 3 judges from the Michigan Court of Appeals office in Grand Rapids agreed that a tire rotation by a mechanic could be considered performed even if the left front lug nuts weren't tightened and the wheel fell off less than 2 blocks down the road. Lehto, a lemon law expert, was not involved in Samuel Anaya versus Benton Chevrolet, Inc. He worries, however, that the decision will become a potato in the tailpipe of an important consumer protection statute, legitimizing sloppy repair work and detouring drivers who need legal help. In the narrowest sense, Anaya lost on appeal, Lehto said. In the broad sense, every mechanic now has the right to start a job, not complete it, and say, okay, I finished it. Anaya's Westland-based appellate specialist Don Fulkerson filed a motion for reconsideration in the Court of Appeals last week. He contends that the panel misinterpreted one of 2 claims made under the Motor Vehicle Service and Repair Act and ignored the other. And that's news. I did not know that the motion for reconsideration had been filed. And several people had asked me about what the next step would be in this process. And there's 2 things you can do. You can actually ask the Court of Appeals to reconsider its position and say, look, you guys made a mistake. Reconsideration is considered to be a really, really tough way to do it, though, because you're asking a panel to say, oh, we made a mistake, and correct it. Most human beings are loath to admit they've made mistakes. And, of course, you could appeal to the Michigan Supreme Court. Now, if the motion for reconsideration gets denied, then they can appeal that to the Michigan Supreme Court. Obviously, they could also do nothing and leave this crazy ruling on the books, as they say. But the case stems from October 2013, when Doris Myricks, who's now 71, took her well-preserved 1991 Cadillac Seville to Benton Chevrolet in Muskegon for routine service and maintenance. There, the technician rotated her tires but allegedly neglected to torque wrench one set of wheel nuts. Myricks was accompanied by her friend Anaya, who's now 58, who had a history of back problems and crimes. And Neil is a reporter for the Detroit News. He's a columnist. And as a journalist, he's doing a really good job here of just telling you the complete story. So he's gonna give you a full version of what's going on. And so the back issues were central to the car dealership's unsuccessful defense of the eventual lawsuit. Anaya's crimes, oddly, helped him win a $40,000 jury award, accompanied by more than $70,000 in attorney fees and costs under the Motor Vehicle Service and Repair Act, the part that the judge eventually tossed out. We'll get to that in a second. When the left front wheel departed its axle, the silver Seville slid to the right and slammed into a curb. Anaya said the impact left him with severe pain in his lower back and leg. Their big defense was that the injuries were all pre-existing, said Southfield lawyer Mark Bogahold, who won Anaya's case. Their lesser defense, he said, was to highlight Anaya's unsavory acts, which include burglary, weapons violations, unlicensed driving, drunken driving, domestic violence, felonious assault, and multiple incarnations of passing bad checks. Bogahold obtained the records from Anaya's most recent tenure in prison, he said, and pointed out in court that it included only a few complaints of back problems over 5 years. In his summation, Bogahold said, quote, I told the jury I'd been counting the number of times the defense brought up the fact that he'd been in prison, and I stopped counting after 22. They still awarded him money. They didn't have to, and they did. And so the point is that the defendants were trying everything here, including going, look, he's a bad guy, he spent time in prison, and they managed to bring up that he's in prison more than 20 times during the trial, and the jury still gave him the money. So that shows you how convincing the plaintiff's case must have been. Then the appellate panel took part of it away, which astonished a Birmingham lawyer who used to defend General Motors against lemon law claims. Edmund Yee is the attorney. The analogy, he said, is that you hire someone to replace your stove. He pulls the old stove out, puts in the new one, doesn't connect the gas line, and the house blows up. Is that to say the guy replaced the stove? Yee said there's a chilling effect if the Motor Vehicle Service Repair Act no longer helps recover attorney fees. And again, remember, he's a defense attorney. That's the hammer in the statute. In cases with damage to the car but no physical injury, vehicle owners have to spend thousands of dollars more for legal assistance than the cost of the repair. The classic term is, the doors to the courtroom would be closed to them. Lehto summarized, if it's a couple of $1,000s and I get 1/3, nobody's made whole and I won't take the case. Benton Chevrolet and its law firm did not return calls to discuss the ruling. The judges, 2 Republicans and a Democrat, made their feelings known in a 6.5-page opinion written by Mark Boonstra, appointed by Governor Rick Snyder in 2012 and elected twice since. The Motor Vehicle Service and Repair Act, adopted in 1974, declares that a shop cannot charge for repairs that are not performed. It also says that a mechanic or body shop employee cannot make, either written or orally, an untrue or misleading statement of material fact to a customer, nor can it hide or omit a material fact that the customer could not reasonably know if the omission tends to mislead or deceive the customer. The dealership asked at trial that the judge not apply the Motor Vehicle Service and Repair Act, claiming it had completed the tire rotation even if it didn't do a bang-up job. The trial judge instead agreed with Anaya that by not replacing all the lug nuts, the mechanic had failed to perform the repair. To Anaya's benefit, Boonstra and the other appellate judges agreed with the trial judge that the Motor Vehicle Service and Repair Act applies to passengers and not just drivers. But to Anaya's detriment, the judges looked up perform in 2 dictionaries and concluded that the term generally refers to completion of an action according to an established procedure. The term does not imply the action has been completed properly, successfully, or without mistake. Boonstra wrote, to accept the trial court's interpretation would essentially turn every incorrectly performed repair into a violation of the Motor Vehicle Service and Repair Act. Lehto, who operates a consumer-oriented YouTube channel from his Southfield office with more than 85,000 subscribers, said that's a misinterpretation of both the letter of the law and the intent. The Motor Vehicle Service and Repair Act is what's known as a remedial statute, he said, designed to solve a problem. Quote, I taught law school for 10 years, he said, and you're supposed to read a remedial statute in favor of the party you're trying to give relief to. A tie goes to the runner, unquote. Fulkerson complained the appeals panel ignored the passage in the law about untrue or misleading statements. When the dealership declared the car ready to go, he said, that's an untrue statement, as evidenced by the fact that the wheel fell off less than a mile down the road. Anaya, meanwhile, still waiting for a check 6 years after the injury and 2 years after the trial. Bogehold noted that the term attorney fees and costs is misleading in cases like Anaya's. The disputed $70,000 plus actually goes to the client, and the lawyer's 33% comes from the total of that and the $40,000 in damages. Depending on the eventual outcome, Anaya stands to receive as little as $26,800 or somewhere close to $75,000, depending on the outcome. Bogehold said Anaya operated a food truck for a while after the run-in with the curb, selling sausages. He has talked of opening a shoe shine stand. He's presently recuperating from surgery for something unrelated to his back. Ideally, the operation was performed completely. Neil Rubin of the Detroit News. And it's interesting there. And like I said, there's a couple little tidbits in there. I talked to Neil a few weeks ago. I put out my video. I put out 2 videos, actually, about this case and the ramifications of it. And I'll put those links down below also. And shortly after the second video went up, Neil called me. And I've spoken to him before. And I said, what's going on? He goes, hey, because my editor said there's this crazy court case involving lug nuts. And he goes, I assume you must know something about this. And I said, We got to talk, my friend. And so we had a long, long conversation. And I told him, I said, look, I said, I'm going to let you know right now. In one of my videos, I said my friend Ed called me to tell me about the story. And I said, Ed is an attorney who defends car dealerships and manufacturers, and he does defense work. And I said, Ed's the one who pointed this out to me. And I said, and later on, after we talked, Neil goes, can you get me Ed's phone number? So, yeah, and I it's one of the numbers I got in my head. I gave it to him, and I said, and so because Neil, as a journalist, wants to talk to people on different sides of the story and get the story from all angles. So as you can imagine, I do plaintiff work and I represent people who want to sue car dealers. You might think, gee, Steve's going to be biased towards the consumer on this one. Let's talk to somebody on the other side. You'll notice that Neil went out of his way to try to speak to all the different people, including putting phone calls into the dealership, going, hey, is anybody there want to talk to me? No, they chose not to, but the point is that he tried. So the interesting thing is that I talked to Neil a couple weeks ago, and I was actually starting to wonder. I've had people call me before to do stories, not Neil, but other people call me before to do stories, and then the stories never appeared, or they appeared so far down the road I'd forgotten about them. And I was starting to worry, going, this story is, in my mind, still fresh. Things. So the story came out. I got it this morning. These are modern day problems, but I got it this morning. I turned my phone on. Ding, 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 ding. It just starts going off. And I'm like, oh, I bet the story's out. So I go to my email, and the first inbox email that I see that catches my eyes from Neil Rubin, and goes, hey, Steve, story just went up. But all the other ones are coming in from people going, hey, Steve, you're in the paper. So it's always a good thing. I've mentioned before that I delivered the Free Press as a child and a young man. And the Detroit News is the other big daily paper here in Detroit. So in the old days, the Free Press was the morning paper and the News was the afternoon paper. And so the guys who delivered the Free Press, we considered ourselves like the Marines. We were the ones who got up and, we put in all the hard work before going to school. And it's kind of like anybody could deliver a paper in the afternoon. But actually, it's just, it's just two different papers. So it's really, really cool to see the article there. And I'm really hoping that, the attention being brought to this case will cause some people to think about it a little more carefully. And so I'm glad to see they filed a motion for reconsideration. I've already had some discussions this morning with other friends of mine who are attorneys, both in Michigan and outside. And I've had several people say, Steve, what are the odds that a Court of Appeals panel, for instance, is going to actually look at something and go, we screwed up? Well, it's happened before, but it's like I said, human nature not to ever admit that you screwed up. But, it could happen. And like I said in my second video on the topic, that the Court of Appeals said they looked at the statute as a whole, and in that holistic approach to it, they came to the conclusion that the statute was not intended to cover all mistakes by mechanics, just the most egregious ones. And I had several mechanics tell me that too, and that's just a bunch of hooey. And as I pointed out in my second video, that the statute actually says that at the end of the work, the mechanic's got to sign a work order that says, I certify that the repairs have been performed properly. And the use of the word properly in that context does mean that the work was completed. Doesn't mean that it was started. You can't say I started it, but it's now been performed and completed properly. Doesn't make any sense. So the idea that they looked at the whole statute, they couldn't have. So maybe they can look at it and go, oh, now that we look at the whole statute, maybe. Or they could also say, gee, the parties before us didn't brief it properly before. Now they briefed it properly. Who knows? That's a possibility too. So there you go. Detroit News, Neil Rubin, great article. Court tightened lug nuts, not guaranteed entire rotation. And he quotes a bunch of people in there. So there you go. Questions, comments, put them below. Otherwise, talk to you later. Bye-bye.